Oh my gosh, guys, today's hearing ended in a major cliffhanger.
All right, I'm going to take a recess before the response. Commonwealth just provided the court with information that causes me grave concern. May have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today.
After the state had argued for their side, Judge Cannoni asked for a 30-minute recess break. And then after the 30 minutes, she came back seemingly either maybe like out of breath, sort of, or maybe there's a lot of adrenaline pumping in her veins. Or maybe she had like an unrelated thing to the courtroom. Maybe it was just like a bad bug in her stomach and she was just like in pain or something like that. I'm not quite sure, but she sounded like it was like intense for her. She decided to push the hearing to next week so the defense did not have a chance to argue their side. Now, is the defense in trouble or is it Mr. Hank Brennan who is in trouble? There's a reason why people can think it's either or maybe even both. And I'll explain why. Attorney Hank Brennan, special attorney actually, is accusing the defense of improperly working with some of the federal government witnesses. In this case, it's the ARCCA experts. If you guys remember the ARCCA experts, a lot of people really liked the ARCCA experts when they testified during trial 1 of Karen Reed's trial last year. They found them to be really credible. They found them to be unbiased, and they found them to, well, be able to explain what did or specifically maybe didn't happen to John O'Keefe. And it was in a way that didn't sound like made up bullshit. Now, you guys got to remember, ARCCA was not hired by the defense. ARCCA was hired by the feds because there is a federal investigation into this. Now, we don't know if it's a federal investigation into Karen Reed or is it a federal investigation into maybe Canton police, maybe Boston police. Special Hank prosecutor is essentially accusing the defense of, well, it seems like violating federal court orders and then possibly misrepresenting information to Judge Cannoni, which is not good. So we have Mr. Brennan, who is going to argue a motion to exclude the employees of ARCCA.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
Now, initially, when people heard about the motion to exclude the ARCCA experts, they thought maybe Hank was trying to disqualify them based on their qualifications, which would be a huge no-no. Compared to what the Commonwealth had for their expert witness on trial 1, ARCCA experts was like a breath of fresh air. But Hank is explaining it's not the issues with the actual ARCCA experts that he has an issue with, but it is with the discovery.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement. Whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason.
Now we're going to time travel over to June 10th, which is day 22 of the Karen Reed hearing. Hank Brennan's going to read the transcript, but you know what? I'll just show you the footage instead.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they...
Today wasn't an especially spicy day, by the way, between Yannetti and the judge.
...provided a report to us pursuant to the Touhy request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to. Well, and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine.
Now, this is when we had to do a whole day of voir dire of Dr. Marie Russell, because again, she jumped on to the trial pretty late, and then they decided to do a voir dire of the ARCCA experts. Now, Hank talks about how he was able to get some new material, which seemed to have troubled the judge.
Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a Touhy letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a Touhy letter, comprehensive Touhy letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
So Hank Brennan was essentially trying to say that, well, the ARCCA experts, they can't testify because I don't have adequate discovery. So, you know what? I took it upon myself to reach out to the feds and ask them for discovery. And then he had to file a Touhy request. And then there was like some non-correspondence. However, when I guess the other attorney pushed the federal government to provide more materials, they were able to finally get something, which was these email correspondence.
So there was email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance, pursuant to Touhy, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses.
Now, March 22nd, 2024 would have been before trial one started for Karen Reed, because I think the timeline for that was it in April that her trial started? April 29, 2024, day one of the Karen Reed trial. So that would have been a month after the email exchanges between the defense and ARCCA.
Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward.
Now, I don't know if maybe the defense was trying to retain the ARCCA for their services, and then subsequent to that, the feds were like, oh, no, you can't work with these experts. These are our experts. Because it wouldn't make sense for them to try to reach out to these experts after they were already told to not work with them.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, Touhy requests, and an insistent, the best I can, to get as much information as I can.
I'm making faces about who provided this information to Hank Brennan. He said that it was not the defense, it was actually the feds, but we'll put a little pin in that.
We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. Witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
Dr. Daniel Wolf did say in trial that it's not uncommon for him to not have access to the actual scene or the vehicle itself, because sometimes when he's working on these cases, he's investigating far back as like 5 or 10 years.
And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Now back to today with Mr. Brennan.
The date of that?
It's not dated. It's not dated. The Touhy request is a recent February response, but they send random documents. There's no real accounting. I'm not saying that undermines the conclusions of ARCCA, I'm not saying they're not qualified witnesses. but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. It would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important.
I actually was a little bit confused about this part where Hank Brennan, he's going to say this is pretty important stuff. I don't understand how it's pretty important stuff. Like, how does it help the Commonwealth in any way? I also did find that during voir dire and then during the trial, Dr. Daniel Wolf did mention about pedestrian fatalities during the evening and night hour. So let's jump to that. This is Dr. Wolf's testimony during voir dire, day 27 of trial. So remember, voir dire, jury's not present, and then not voir dire, the jury's there.
Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing. And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
This is his testimony for the actual trial to the jury. So on day 30.
Example of human factors in the field of accident reconstruction. So I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night. There's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them. Earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
Now, see that last part right there where he talks about the visibility and lighting and the human factors? Well, it was testified to during voir dire, and then he also testified it in front of the jury. Now, I know Hank Brennan was not the attorney at the time. It was actually Mr. Lawley, and it's probably a lot of information that he's absorbing in right now. But I guess I don't understand is how that little bit of information would have helped the Commonwealth. I know the overall scheme of it, of them providing notes in the outline and then giving it to the defense and not the Commonwealth. I'm not too sure what Mr. Hank Brennan was commenting on about, how that little information could have helped him.
It would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have.
But maybe he means that would have been nice to have when Mr. Lawley was prosecuting the case. But how would that help Mr. Lawley is basically what I'm asking.
Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine.
But he did say it in the trial and in the voir dire.
Shh. Don't tell them. Have you qualified as an expert in court before?
But I think the point that Brennan's going to make that ARCCA was coordinating with the defense about what was going to be said and not said.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not.
So the caption said $3,000, but he's saying $23,925.
That's not Trimble. That's not trial by ambush. That's getting duped.
Now, people did point out that maybe that $23,925 bill, maybe that was a bill that was with the Department of Justice for the federal investigation, not necessarily a bill that ARCCA was giving to the defense to pay for. But I don't know if Brennan doesn't have the actual details of the bill. I'm assuming not. Seems like a smart guy. But if he didn't have the full details of the bill, like who was paying it, then it would have been more prudent for him to probably say to the judge, like, hey, like, I don't know if this is a bill the defense paid, or maybe this is just a bill by the Department of Justice.
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before the
What time did this happen? Did she maybe she was just hungry and she wanted to take a recess right away? It could have been that, maybe. I'm not quite sure. So we take a recess, and it is a recess for 30 minutes. Now, Laura, made a point saying that the judge should have just let the defense argue their point, because later on, well, the judge is going to push this hearing out by another week. So she should have given the opportunity for the defense to reply. And if the defense wants more time, then they should have been the one to request to push it out a week later. However, I was watching Emily Baker, and she thought that it was a good idea for the judge to allow the defense to have more time to respond to this. It seems like a very serious accusation. And honestly, if I was me and I was given this serious accusation, I would not want to respond on the fly. Maybe I'm like super confident I would want to, but I would probably want to have time to gather myself, get all the evidence, and then really argue what really happened and my side of the story. So I honestly think it was good for the defense to have this 1 week break. But I did see that people did mention that, oh, well, this gives like a whole week for the press and everyone to marinate on, this could look so bad for the defense. This is such bad optics for the defense, and it was unfair for the defense. However, you know how the defense is. If they really wanted to argue something, I'm sure Mr. Jackson, Mr. Yannetti would have gotten up really quickly and like, you know what, actually, Judge, I want to address this right now. Now, I'm not saying because they didn't address it right then, right now, it's because they look bad. It could also just be like, okay, well, we got another week's time, and let me just get all my ducks in a row and really destroy Mr. Brennan. So let's talk about the two major issues: violation of a federal court order and misrepresentation to this court. Let's go back to Mr. Yannetti. This is what he said again.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the Touhy request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So
I think the judge is going to have to determine, do these emails between Alan Jackson and Dr. Daniel Wolf from ARCCA, is this considered prepping with the witness, something that the defense was not supposed to do? And then also with the outline and the notes that are in the outline, is that prepping someone? It kind of seems like it.
I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being...
So when Yannetti tells the judge that they've only spoken to the ARCCA witness in regards to the coordination of their testimonies and also their background, is that a misrepresentation to the judge? Is that just straight up lying?
Spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Maybe there's a way to interpret coordination of their testimony. But when you guys hear coordination of testimony, what are you guys thinking? I'm thinking like, let's coordinate a time for you to come in and testify. But I wonder if it could be spun as like, well, we were coordinating what they were going to say for their testimony. But wouldn't that count as like prepping the witness? I don't know. I have questions. Then also, I went back to day 27, which would have been 10 days after Mr. Yannetti tells the judge that they were hired by the federal government, the ARCCA people. They provided a report pursuant to the Touhy request, could not prep for the defense, and that they only worked to coordinate the testimony and for discussion of the outline, I guess. 10 days later, and this is day 27 of trial, well, this is Mr. Jackson. This is what he says.
Right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Renshaw?
Well, I thought that would help both of you.
Dr. Wolf, Dr. Renshaw, those are two ARCCA guys.
Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have.
So that communication right there between Mr. Jackson and Judge Cannoni, is that a misrepresentation? Is that lying? Or what if the email dates are incorrect? But Brennan said that the emails happened between Alan Jackson and the ARCCA guy. This was back in, what did he say, like March, right? I think in March 2024. So that would have been 3 months before this. Now, after 30 minutes of the fan just spinning, Judge Cannoni comes back. And when she comes back, she's like, okay, well, let's continue the hearing in a week from now. Cliffhanger. However, Mr. Brennan is not done yet. Mr. Brennan comes up, gives us a timeline and a major correction. But is it a major correction? What do you guys think?
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
I do have it sped up a little bit, but yeah, she was kind of like breathy in my opinion. Now, Mr. Brennan's going to come up and he's going to give us a little timeline.
Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another Touhy request, 2024. January 6th, we filed our notice of intention to exclude ARCCA Experts.
I'll slow it down a bit.
January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA Experts and that if either party wanted to engage, the original materials are still protected.
So February 6th is going to be a very important date. February 6th. Because after February 6th, then either side, most likely the defense, can contract the ARCCA Experts and work with them and hire them and then use the original materials that was used in the federal grand jury.
This was a change in position about whether a party could engage.
However, it was before February 6th. That would have been violating the federal court order, I'm assuming.
On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, so people are like, well, did Mr. Brennan purposely misrepresent the facts? I have a hard time believing someone would do that because obviously the court is there. The defense attorneys were very smart are there. We are here. If he's like fucking some shit up, then he's going to get called out for it. So there's no point in misrepresenting something just for the shits and giggles of it or just to, just be disingenuous. That doesn't make sense to me. I genuinely believe that Mr. Brennan truly believed when he was making the argument in this motion that it was the federal government who provided him with the emails and not the defense. And here's why. 3 times he mentioned it.
And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, Touhy requests, and an insistent, the best I can, to get as much information as I can.
What's the date of that?
It's not dated. It's not dated. The Touhy request is a recent February response, but they send random documents. There's no real accounting.
Now, did you guys catch this part? Because I think it's Attorney McLaughlin that handled the correspondence towards the tail end.
Unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some.
So what am I thinking? I'm thinking, did Hank get wrong information from Attorney McLaughlin? Did he maybe misunderstood Attorney McLaughlin? And during break, Attorney McLaughlin was like, oh, actually, Hank, I'm so sorry. You actually misunderstood me. It wasn't the feds that gave it to me. It was actually the defense. And that's why he went up there and corrected himself. And then lastly, did he misrepresent? Which I already addressed that. I don't think he would do that because it would just look dumb for you to be arguing something and then later on someone just call you out for being completely wrong, right? So the court ends today on a major cliffhanger and we don't get to hear from the defense. But I did hear that there were reports of Alan Jackson leaving the courtroom and people were able to catch like a quick little interview with him. I don't really think it was an interview though. I think it was more like a drive-by comment. They asked him if he had paid ARCCA and he says, no, of course not. Now, did you guys think that Alan Jackson and his team looked phased when they heard about these accusations? I mean, I noticed this part here.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, Touhy requests, and an insistent, the best I can, to get as much information as I can.
That communication to me could look like Attorney Little turning to Alan Jackson and saying, weren't we the ones that sent the emails over to them? Alan Jackson turns over and was like, yeah, of course it was us. But I could be completely wrong. I've listened to other coverage about this, and there were some serious talks about possibly pulling Alan Jackson from this case. And I remember this from the Depp v. Heard case. There were some attorneys that were representing Johnny Depp via pro hac vice, which means that we're going to have an attorney who is Virginia-based. I forgot who was the Virginia-based attorney. Oh, it would have been Ben Chu. Yeah, because Ben Chu was like East Coast. Ben Chu would have been the one who was the main attorney. And essentially, when we have other attorneys who are going to be coming in as pro hac vice, well, Ben Chu's going to make sure that these attorneys are going to behave. They're going to follow the rules. They're going to make sure they follow all, like, you know, the ethical guidelines and stuff like that. Pro hac vice allows Alan Jackson to practice in Massachusetts because, you know, he is actually an attorney from LA. Now, if Alan Jackson misrepresented to the judge in regards to not having communications with ARCCA, you know, not prepping them. I mean, it was also Yannetti as well that also communicated that. So I don't know how that's going to really weigh there. But the point of this was they made it seem like the worst sanction possible would be to have one of these attorneys removed, possibly Alan Jackson. And, you know, it would have looked really good for Hank Brennan's argument that it was the feds, not the defense, that provided these emails, that provided this outline, the communications between ARCCA and the defense. But, you know, even if it made his argument a lot better, I don't know if it still takes away from the substance. Because if the defense had violated court orders and prep with ARCCA when they weren't supposed to, and then they misrepresented that to the judge and lied to her, that could still look really fucking bad. But here's the thing. The fact that it was the defense, and you know, they're not rookies. They're all smart attorneys, and they're not like, you know, I should name other attorneys that we don't like, but they're smart people. They're smart guys. I can't see the defense turning things over that will look really bad for them. Basically just self-snitching. So that's why I'm thinking maybe it's not a big deal. Maybe there is an explanation out of this. Like, for example, the $23,000 bill that ARCCA had, maybe, again, it was their bill with the Department of Justice and not necessarily with the defense. Or maybe they were contracted after the February 6th when they would have been able to, when ARCCA was essentially released by the feds and were able to work with either defense or the Commonwealth. And, you know, even though the judge didn't give the defense a chance to respond, well, we know how the defense is. They don't care. They're not scared of the judge. If they really wanted to say something, they would have said it to the judge right then and there. They would have gotten up and just tried to say something really quickly. But I do think it's a good idea to have a week's time to prep, because these are serious accusations that are possibly made at you, and give it a week time, prep for it, and then come back full force and then make your arguments. So guys, that was a pretty crazy thing that happened today. So I just wanted to cover this, and this video was a lot longer than I thought, but you know, I wanted to be as thorough as I could. I wanted to provide all the previous footage from the trial to see what was said, what the ARCCA people testified about, and all that stuff. But anyways, guys, this will be to be continued for next week. I think I might try to cover that live. I think so, because it's such a cliffhanger. I don't know. It's like some juicy content right now. All right, guys. Well, that's it for today. We're also covering Blake Lively and just about Joni stuff as well. So feel free to check all that out. And I do want to do a live stream this week. I don't know if we're going to have time, though. But there's so much backlog that I have for the live stream, for all the live stream stuff. So I'm hoping to cover that. But anyways, I appreciate you guys being here. Hope you guys have a good one. And I will see you guys soon. Have a good one. Bye.